Next, we will hear from Director General of Trial and Appeals Department at JPO, Mr. Futoshi Yasuda. Thank you very much for your kind introduction. I am Yasuda, the Director General of Trials and Appeals Department at JPO. Thank you very much for joining us today. Today, we would like to present you on the latest trends of trial and appeal policies in Japan. There are three parts. First, starting with the statistical trend in the trials and appeals, and secondly, the promotion of online proceedings and digitalization, and also online improvement in information sharing and international cooperation. At first, I will talk about statistical trends in the trials and appeals. Today, we are going to mainly talk about this portion in yellow in the middle. So if it is rejected, then there will be a appeals against the examiner's decision or refusal, and there will be opposition to grant patents in evaluation trial, etc. And I would like to talk about the statistical numbers on these proceedings. Starting with the numbers, recently in 2022 or 2021. So if you look at the proceedings in the middle, what about in examination stage? In numbers of cases, there are about 230,000 cases in designs, 31,000 in trademarks, and 170,000. But in case of a decision, there is much more. That is more than 210,000 cases for the trademarks. However, in the case of rejection, it will come to trials and appeals, so that would be more than about 20,000, and then design 300, and the trademarks is 1,500. But for patents, there will be a preliminary examination, and then via that examination, they will come to the trials board. And then for those 9,000, we are going to do the additional proceedings, and then we decide if it will be rejected, or about 20% of that will be maintained as the rejection. So that's 20% of 9,000. That is about a little less than 2,000. And then if there is an opposition, then you go to the district court. And the numbers for that is very small. That's 19 out of 2,000. So it's only 1%. On the other hand, for the inter-parties trial where there's a conflict, it includes the invalidation and correction and revocation. There's not that many, 310 for patents, 13 for design, etc. But when there is a dispute, there's a high ratio of going to the court. In case of patent, there are 69 cases that went to the court, and that's because with patents, in case you reject them or you acknowledge them, you have to do a lot of disputes. So 69 cases is 49% in terms of the ratio. And then for the oppositions, anyone can make an opposition. So that's 1,300 in patents and 500 cases or so for the trademarks. That's the volume. However, in case of a courts, that's very small. You see the numbers at the top, and they are very low. Now, I would like to talk about the trend. That was numbers of cases. But when it comes to the examiner's decision of refusal for patents, around 10 years ago, there were about 25,000 cases of the appeals against the examiner's decision, but it's been lowering to around 16,000 cases now, recently. But the last year, it went up because there was a government target to shorten the period. So in the examination stage, they did a lot of final dispositions. The filing itself was flat, so we think it was a temporary. Average duration of proceedings was 11.7 months. So the number reversed. And next is the trademark and designs. The gray color, that's design. Annually, there are about 350 cases a year. And then for trademarks, recently it's been increasing. You see the yellow bar. There were about 1,500 cases last year, and that's because the filing for the trademark jumped up all of a sudden. So we had to do a lot of proceedings for trademarks, and that's being reflected here. The average proceeding period was 6.8 months for design and 8.6 months for trademark. Now, in the appeals stage, how much of the examiner's decisions were reversed, and that's the percentage here. Around 80% have been revocated and it was registered. And it used to be around 60% for patents, and then recently the number has been rising to around 80%. For design and trademark, the trend has been rather flat, and that's because, as was explained a little bit, we are being more selective in the cases that we deal with. And for the trademarks, last year the number dropped a little bit, and that's because it's not that we made a little bit of change, but it reflects the judgments of the courts, and also we are listening to the user's voice and being selective in our decisions. Next is the opposition status. This is from April of 2015, and this opposition started back then, and then it's been around 1,000, a little bit more than 1,000 all along. And especially, as we mentioned in this year's symposium, there's a particular area where there are oppositions in, and then you can use this system differently depending upon the field. So what is the result of oppositions? And you see numbers for patents and trademarks. Well, first of all, for patent, so without making any correction, around 37% of patents were maintained as they were, and they were maintained, but with some correction, stood at around 62.5% with some kind of a correction. So that is relatively high. And then for the trademark, the rate of maintenance was as high as 67%, and the revocation, including the partial revocation, was 10%. So in case of a trademark, the registration has a higher probability of being maintained. And then trials for invalidation. Well, first of all, the numbers of trials for invalidation has been decreasing. It used to be more than 250, but now it is around 100 or so. And at the same time, this yellow line graph, the rates of being invalidated, either partially or wholly, you don't see the number, but that is 36%. It used to be 29, but now it's 14% recently. And this is the trends in requests for Hantei or advisory opinion. We just wanted to show you this for your reference. And depending upon the year, there is a jumps, but are around 40. Altogether, a number has been hovering around 40. And then the revocation of the against the trials and appeal decisions. It's hard to see, but there is a inter parte and an ex parte. Both of them are included. And for the ex parte, the numbers or the rates, the cases of going to the court has been going down a lot. And as we said, that's 19 cases in case of patents. And on the other hand, for the inter-party with disputes, the numbers have been decreasing, but not as much as the ex partes. Next is the infringement lawsuits and invalidation trials. When there is an infringement lawsuit, for almost the cases, at around 100% of probability, the rights become invalidated. And then this is the relationship between those two. For the 30 cases where there's an invalidity defense, at the same time of being invalidity defense cases, they are also judged as the trial for invalidation. So that means 81% of the cases invalidated, both at court and also at JPO.
And as for the double track proceedings in Japan, and that's what we call in Japan, and the results between the court and the JPO. And I'd like to tell you some of the analytical results. And when JPO says valid and the court says it's invalid, those cases I'm talking about. And the concordance rate between the JPO and district court, in total, that's going to 81%. So they are rather well matched, and no dispersions between the decisions of JPO and court. And some of the different opinions, it's around 20%. But as for the proceeding cases, and for the invalidated decision, the percentage was 13%. So 65% was maintained. So all in all, and we have rather affinity between the JPO decisions and the court decisions. Next, I'd like to talk about our promotion of the online procedures and digitization. Last year, I talked about this. About 2 years ago, in the midst of COVID-19 pandemic, and we started to establish some online procedures. And during the COVID-19 period, and we have facilitated some of the smooth progress of the proceedings, and also in consideration for the people from the remote site. And I'd like to tell you about some of the actual use case. And after October 21, about 70% are on the oral proceedings. So 70%, all of them, and that's for the participation of either party or both party, including the 70% are quite high, the participation for the oral proceedings. And after COVID-19 has downgraded to class 5, so that showed a bit of the decline, but still 60% is the rate for the online proceedings against the total proceedings. So that's going on. And January 24, and we have some, right now we have some limitations for the online, only for the invalidation trial and objections. The rest of them, you should be based on the paper procedures, and including some of the judges, the decisions. But the January 2024, everything will be eligible for the online applications. They can use software issued by a JPO, and then you can provide the application form and transmittal slip and the first document and the attached document. So you can submit through the online media. That's going to happen in January 24. And of course, we are going to maintain the paper-based procedures, so you can resort to the paper. But we would like to promote more online the applications procedures. and another activities of ours. And we have telework, free address, and paperless initiatives. So we have less paper. Then, with less paper, you do not have to assign your own desk with the documents. And if you do a telework, we have some vacant desks and chairs. So for the past 18 years, we have the two locations in the METI building and the Sumitomo Real Estate Toranomon Tower. We have the two separate offices, but for the first time in 18 years. And May this year, we became a one JPO with the consolidation of the two different offices. And we have some. The department for the trademarks still remains on the separate locations, but we are going to promote more office consolidation. And the third one is for operational improvement, information sharing, and international corporations. This is for the revision of the manual for trial, and that's for the principle on the prohibition of the double jeopardy. So we need there has been a discussion that we need more clear definitions of the prohibition of double jeopardy. And there has been opinions to review the laws and regulations. But still, the scope it is still difficult for us to define the scope, and we have some case studies of the past, the sentences and the judgment. So within the manual for trial and appeal proceedings, and we are going to provide some clearer definitions of the trials for invalidation and the scope of the evidence. And we are now amending the manual for trial and appeal procedures, and as for more online proceedings, and we are now using a version 19, and we are now working for a version 20. Right now, we are soliciting the public comment for the compilation of the version 20, and including some of the reviews for the online application procedures. And we are going to have clear stipulations of some of the items which has yet to be clarified. So I hope that you will spend some time if you're interested in. And we have been, since 2006, we have conducted study group sessions for trial and appeal practitioners. And this is to disseminate the knowledge and the notifications for the user bases. So, and we are going to provide some of the reasoning of the decisions. And for these study groups, and we have the representative from industries and patent attorneys and attorneys at laws and the judges, and some of the judges from the IP High Court and the Tokyo District Court as observers. And as for international corporations and our trial and appeal department, we have been quite active for the international. And we have the JPO, CNIPA, KIPO joint expert group meeting and the Japan-Korea trial and appeal expert meeting. And we also have the another and the expert meeting. Last but not least, and the JSIP Symposium is supposed to be one of the most important events for us. That's an annual event since fiscal FY 17, and we have every 2 years. So we have Japan, China, Korea, and ASEAN, and Japan, and the US, and Europe. And we are taking some of the feedback survey. So, and we'd like to select some of the topics of your interest, and so as to provide more meaningful information. So this concludes my presentation, and thank you very much for your kind attention.
Thank you very much. That was Mr. Yasuda, Director General of Yasuda.